I'm an attorney with the Alliance Defending Freedom. We are based in Scottsdale. We're a nonprofit that does religious liberty litigation. We also work to protect the family and to protect life. As a matter of fact, I head up their life team, and we have several litigators that are here in country, about 50. We're international now, and we have about 250 employees. And we provide all of our services free of charge. So just so you know, we have everything I'm going to talk about today, you can access in this booklet right here, which you can get at our website, adflegal.org. And all you got to do is free. And all you got to do is download it, and you can see what it is. But at any rate, I'm going to talk about some cases today. And just so you know, because we're a nonprofit and we advocate for the right of people to freely live out their faith, whether that's at work or in the public square or at school, in your home, believe it or not, that's being challenged now some. We do that all free of charge. We don't make any charge for our services. That's why this booklet is free. That's why any of the attorney time that we give, we pick up all the expenses of the cases, and there are several other things that we do that I'll talk about here in a minute. But what I wanted to do is start out with talking to you a little bit about a sense of purpose that many business people have. And as a matter of fact, as Christians in commerce, your sense of purpose comes from your biblical worldview. But there are a lot of other companies out there that have a sense of purpose that's different than or bigger than their making money. For instance, Starbucks. Many people think of Starbucks, you think about coffee, expensive coffee. You think about very high-calorie treats. You can get like 600 calories for one of those donut things in there, man. But they also have a very distinct business purpose. As a matter of fact, the CEO, Howard Schultz, says that when we began Starbucks, what I wanted to do was try to create a set of values, guiding principles, and culture. Values, guiding principles, and culture. That sounds a lot like what a business who's owned or who's managed by a Christian might have as their mission statement. Values, guiding principles, and culture. And as a matter of fact, they have an initiative going on that you may be aware of called Race Together Initiative, where they're combating against racial discrimination. And that has nothing to do with coffee. And so they have a statement, a mission, that's part of their mission as an organization. Now, many people say, well, an organization cannot have a significant purpose other than making money because it's a corporation, it's not really people. Well, corporations are made up of people, and as a matter of fact, the Supreme Court recognized that. You are also, I'm sure, familiar with Hobby Lobby. Their statement of purpose and religious mission is a little bit more well-known, and it's a lot more biblical from a biblical context. Theirs is, we are committed to honoring the Lord in all we do by operating the company in a manner consistent with biblical principles. This is in their literature. You can go online and you can find it. It's something that they advertise. So it is perfectly legal. And as a matter of fact, you'll find in a second, we actually encourage you to adopt a mission statement if you're a secular business but run according to Christian principles. As a matter of fact, in this booklet, you can find an appendix, in the appendix 1, a model statement of religious purpose. One company that you may not have heard of is the Hahn family. It's called Conestoga Wood. It, along with Hobby Lobby, were up at the Supreme Court a couple years ago challenging the Obamacare abortion pill mandate. Y'all familiar with that case? And that case went all the way to the Supreme Court. The Conestoga Wood was Alliance Defending Freedom's client. As a matter of fact, I got the privilege of representing this Mennonite family from middle central Pennsylvania. Anybody from Pennsylvania? There's some Pennsylvania. So out in the middle of Amish country, these were Mennonites, not Amish, so they still dress conservatively, but they drive cars, and they have a pretty modern wood-making, cabinet-making business. And just a fantastic family that that very, very hesitant to take a stand, but when it got to the point where the federal government was telling them that you have to cover abortion-causing drugs in your employee benefits plan, they said, we just can't do that. And they went to court. They were represented by one of our allied attorneys. We have about 3,500 allied attorneys around the country. We have 50 in-house attorneys that litigate full-time for ADF. But we have over 3,000 attorneys that we've trained to do this kind of work, and several of those are in Pennsylvania. And they represented Conestoga Wood at the trial court. They lost. Went to the Court of Appeals for the Third Circuit in Philadelphia, lost again, and asked us to come in, and we came in and represent. Went to the Supreme Court. In our case, along with Hobby Lobby, was granted review by the court, and the court found that their rights, that the federal government did indeed have to recognize that they could run this secular business according to their conservative Mennonite principles, and they couldn't be forced to cover drugs that violate their convictions. So, thank you. And one of the reasons why they were able to establish that, and the government didn't even contest, that their company, Conestoga Wood, had this religious conviction regarding abortion, and of course there are many other issues that you can make sure in your mission statement, but that helped us a lot. So you can have a religious statement, you can run your company according to religious convictions, whether you're the owner or maybe you're a manager, you're in senior leadership. There are some restrictions on that. There are some parameters. You can't, if you're a secular business, you generally can't run it like a church. Any people here that are on staff with their church? I don't see any of that. Okay, good. So I can skip that slide. That'll make us go a little bit faster. So I don't have to talk about that. But the parameters in general are Title VII. You've all heard of Title VII. It's a federal law that we're going to really focus on here in a second. There are also local laws and by state and local ordinances that restrict what you can and can't do with your business. And mainly it has to do with discrimination based upon the characteristics you're all aware of: race, religion, sex, and some of the local ones include sexual orientation and transgenderism, which we'll talk about here in a second. The federal law, Title VII, does not prohibit discrimination based upon those. And then the last one is executive orders. If you do any business with the federal government, sometimes they say, as a condition for us doing business with you, you have to agree not to discriminate based upon religion, or you have to agree not to discriminate when you hire somebody or in provision of your service based upon other things. So let's talk a little bit about Title VII. And incidentally, I'm going to have a time for questions. So if you have a question, write it down, and then we'll take about 5 or 10 minutes when I'm done to talk about that before my colleague Eric Hall comes up. He's going to talk about employees and employment in the public context, basically if you work for the government. What I'm talking about is when you work for a private company or you own a private company. So Title VII, what does Title VII do? Title VII is a federal law that was passed back in the 60s, and it was designed to eliminate the badges of slavery, because lots of times people, even though we could no longer hold African Americans as slaves, there was still a lot of discrimination going on. Title VII was primarily designed to prohibit discrimination based upon race, but it also prohibits discrimination based upon religion, sex, and as a companion law is the Americans with Disabilities Act, the ADA. I'm sure you're familiar with that. It's also enforced by a federal agency called the Equal Employment Opportunity Commission, the EEOC. I'm sure you've heard of that. All of those laws are enforced by the EEOC. Now, when do they apply? They apply to most businesses. If you've got 15 or more employees, you're not just a small business, then Title VII applies to you, and you can't discriminate based upon race or sex or religion or disability. It also applies to religious organizations, but in a very limited fashion. I'm not going to get into that because we don't have any of y'all here who are part of religious organizations. But if you ever have a question, like I'm sure you're maybe on boards of your church or members of your church that participate in hiring, firing decisions that your church makes, there are some restrictions on that. But generally speaking, a church can decide that, look, we only hire people who are believe like we do. Make them sign a statement of faith. Churches, religious organizations like Alliance Defending Freedom, like ADF, we can discriminate based upon religion. But if you're a part on the board of any of those, pregnancy center, crisis pregnancy centers, that kind of thing, and you ever have an issue about that, go online, get the booklet, and give us a call. We can provide you advice free of charge. And then just to keep in mind that even though you may have a business that you say, well, Title VII doesn't apply to us because we only have 14 employees, you work in a state probably that may lower that threshold. And that varies from state to state. If you're in more liberal states, sometimes they say if you only have one employee, you can't discriminate based upon all these things. California, I think, is one of those. So that's when Title VII applies, and that's who it applies to. All right, general rules. The general rules for you sharing your faith and having your faith as part of your business are these. They're really only four, and that is you can't condition agreement with your religious purpose upon employment with your company. So if somebody says, I'm an atheist, you can't refuse to hire them. You can't refuse to promote them if they're doing a good job. You can't refuse to give them a raise if they're doing a good job. You certainly can't fire them if they're doing a good job just because they're an atheist. So that's one of the things that it prohibits. You can have religion in your workplace, but you can't condition job security based upon agreement with those beliefs. The other thing is, when you're conveying those beliefs, it can't be done in a harassing way. You can't ask them to church 52 times a month. That's just, if there's pervasive and unwelcomed harassment that affects how they do their job, that's something that Title VII covers. Also, this doesn't really apply if you're an owner, but if you're just an employee and you want to talk about your faith at work, or if you're a supervisor and want to talk about your faith at work, that generally is allowed certainly if it's not discriminatory, and certainly if it's not harassing. But the third thing is it can't be disruptive. If you're spending all your time sitting around talking about whether Jesus is coming back because things are looking really bad, or instead of doing your work, then obviously your employer can fire you for that. And then the last thing is that if somebody does not want to be exposed to your faith at work, or if they have a particular religious belief that they need to exercise at work themselves, for instance, to dress in a certain way or to have off a certain day of the week because of their religious convictions, Title VII requires your company or you as a supervisor to attempt to accommodate them. You can't just blow them off and say, well, if we give you an exception, we have to give everybody an exception. No, the law says you have to try to give them an exception as long as it wouldn't cause, with the law terms, an undue hardship. And we'll talk about that here in a second. In order for the accommodation provision of Title VII to kick in, you have to have a sincerely held religious belief. If you have a religious conviction to share your faith with others anywhere you are, as long as that's not disruptive, and long as that's a welcomed way, done in a welcomed way, your employer has a duty to attempt to accommodate that. But it has to be sincere. You can't just make it up. For instance, I actually had somebody call me at one point and contact us at ADF for free legal service. It was a kid from Northern California, and he said, man, my employer won't accommodate my new church that I just formed. It's the Church of the Divine Cannabis. So the guy basically formed this church so he could smoke weed. And that's not the sincere religious belief. It was a sham. Title VII doesn't protect that, and you don't have to accommodate that. That's actually a true story. I've got another great one too from Colorado. I was just in Colorado, and long story short, I get Uber I was speaking at Colorado Christian, and I get in the car with this guy. And it was kind of interesting. He drove a brand new Mercedes, but he looked like a few steps up from a homeless person. And he was, just kind of shabby. And I said, so I could tell he wasn't from Colorado. What brought you to Colorado? He said, marijuana, man. So he was there for marijuana, was in the marijuana growing industry. And anyway, that if I have time, I'll tell you the rest of that story. It was pretty funny. I did get safely to my hotel. Then the second thing about accommodation is your employer has to be aware of it. You can't just say, I have this sincerely held religious belief to be off on Sundays, and my employer always schedules me on Sunday. Well, did you ever ask your employer not to schedule you on Sunday and explain that you have a deeply held religious belief not to work on Sundays? If you do, the best way to do that is in writing. Then the employer has an affirmative duty to try to accommodate you. Now, there are limits on that, and that is, for instance, they don't have to spend a lot of money to go do that. For instance, they don't have to go hire somebody to replace you on Sunday. If it would cost them money, more than just a couple bucks, then they don't have to accommodate you. If they would have to violate seniority agreements, they wouldn't have to accommodate you. And that's where the no undue hardship comes in. If it would cause the employer undue hardship, if they would have to hire some people to replace you, if it would completely disrupt the way they do things, then they don't have to allow you off on Sundays. But if there's somebody, for instance, who is a coworker, who is a Seventh-day Adventist, doesn't work on Saturdays, and they said, we'd be glad to work for you on Sunday if you'll work for us on Saturday, and you work that out, and the employer has to allow you to do that as long as it wouldn't be disruptive. So that's the accommodation. So let's apply this to some common questions. I'll ask the questions, then we'll go through them here in a second. Can you share your faith at work? Can you decorate? Can you have Christian symbols at work? Can you have a Christmas tree during Christmas time? Can you have a Bible study? Can you permit, for instance, employee groups to meet who based upon their faith? Can you regulate grooming and clothing? So let's take an example here real quick of my early days. So y'all are laughing, that looks like Sam Elliott, because it is Sam Elliott. But I used to have a supervisor named Elmer that looked just like Sam Elliott. He kind of even talked like him, had a real low voice. Had that droopy mustache and kind of long, bushy hair. Except I think, I've never met Sam, but I think Elmer this was at a warehouse that I worked at. There were only 4 employees. I think Elmer was about twice as big and had hands like, I don't know, man. They looked like they were huge. He could pick up a 75-pound coil of aluminum with one hand and just and carry one in both hands, walk around with it like it was nothing. He was a huge guy. He was the supervisor. I was the assistant manager, and there's a picture of me back when I had hair. I know you probably didn't think I ever had hair. And my wife, you could tell I married up quite a bit, even though she is making a face. It's my wife, Suzanne. I was the assistant manager. Russell, who looked exactly like Mickey Rooney. I'm telling you, he looked exactly like. Now he wasn't as jovial as I assume Mickey Rooney might be. As a matter of fact, I had just gotten out of law school. I was taking the bar, and I'd just gotten married, so I had to earn some money. So I was and Russell always referred to me as that gosh darn lawyer, but he didn't say gosh darn. He was the outside sales guy. He didn't work for me. He worked directly for Elmer. I didn't have any control over him, and we had a warehouseman named James, who was a huge Cowboys fan. Now, I'm a Cowboys fan too, so James and I got along pretty well. But he actually looked a lot like Emmitt Smith, and if James were here, he would be really excited that I compared him to Emmitt Smith, who is a great guy. So if I decide, actually this actually happened, I decided that I invited James to church. Now, James was probably a marginal believer. We didn't talk much about faith. He was an extremely hardworking young man. And James agreed to go. Actually went to church with me, which was interesting. But anything wrong with me as James' supervisor inviting him to church? Nothing wrong. Now, what if James had said no, and I asked him every day for 30 days in a row? It might be harassment, especially if he said, man, I don't want to hear it anymore. Stop talking to me about that. Now, the good news is James and I had a great relationship. He came over to the house a little bit. I went to his house some and met his parents, except his grandmother, who didn't like white people, so she didn't let me in the house. It was pretty funny. So I went over to James' house and met his mom and his brothers and everything. Great people. We had to go by his grandmother's house, and I get ready to go out the door, and he said, Kev, just stay in the truck. I said, really? He said, yeah. my grandmother doesn't like white people. I said, oh, okay. So, I'm sure she had a good reason for not liking white folks. But James and the rest of his family were very, very friendly to me. We got along great. James and I didn't have any. Now, what if James would have invited me to his church? I'm his supervisor, and he would have invited me to church every day. Now, he never did this, but what if he did? And I thought, man, that's kind of harassing. Any problem with that? Well, actually, no, because James doesn't have any power to hire or fire me. Doesn't have any power to tell me what to do. Now, I got all the power in the world to fire him. That might be a stupid thing for him to do, but he doesn't have any authority over me. So harassment usually involves some sort of authority type of issue where they feel pressure to agree with your beliefs, or they can't do anything about it. I can make James have an assignment somewhere where he doesn't even affect me. So probably not a harassing thing. Very rarely do you ever see harassment from either sexual or religious or whatever going from somebody who's just an employee harassing their supervisor. It just doesn't happen. And that's the practical reason for it. Now, I guess technically it could be possible, but it's almost unheard of. Now, what about Russell? What if I decided to invite Russell to church 30 times a month? What do you think? It's possible it could be harassing because he's just like sexual harassment. You can sexually harass a coworker just by creating a hostile work environment. If it was a hostile situation where he didn't have any choice but to listen to my talking on and on about my faith, well, then that might be a problem. But not nearly as big a deal as if I did it to James. And then what about if I asked Elmer to church? He would have probably just beat me up. Yeah, just take me out and slap me around out back a little bit. Probably not a problem at all. What if what if we got Elmer saved? Elmer was an interesting character. He spent a lot of time, well, I'm not going to say that. Anyway, Elmer wasn't a Christian. Let me just say it, but a really nice guy. What if he got saved and decided he was going to have Bible studies every day, or even once a week at the workplace? Any problem with that? Maybe. Why do you say maybe? Yes. What she said was maybe if he made it mandatory, but as long as it's open and people are free to come and go as they please, then it's okay. Another thing that kind of a side issue on that is when you have it. If you have it at 10 o'clock in the morning and everybody who goes can kind of get a break for 15 or 20 minutes, but if you don't want to go, you got to work, that might be a problem. You need to have, if you're going to have a Bible study, certainly has to be voluntary, but the leader can run it. It's not a problem. As long as he's not communicating to everybody that, look, if you come to the Bible study, things will go a lot better for you here. You get a little bit easier assignments. I'll speak a little bit more favorably for you when it comes to raise time, that kind of thing. You can't have any of that. You should probably have it before or after work, or maybe during lunchtime when everybody's on break and there's no advantage to attending. So just keep that in mind if you decide to have a Bible study. The other thing is, the last thing I'd like to talk about is grooming and clothing. These cases started out years ago with situations where oftentimes a conservative woman did not want to wear slacks, and she or a Jewish person wanted to wear their yarmulke, their head covering, and the courts generally found that as long as that didn't cause any kind of safety concern, that would be a problem. The more recent cases were often involve Muslim employees who have to either have a beard or a head covering. And as a matter of fact, what the courts have generally held that if a man is supposed to have a beard, generally speaking, you have to accommodate that religious conviction unless it would present some sort of safety problem, like if they have to wear a respirator and it doesn't fit properly if they have a beard, then you don't have to accommodate that requirement. The most recent cases are involving transgendered individuals. That's the hot topic right now. And we have a case in Kentucky where a funeral home director has an employee who decided that he was a woman. So he wants to come to work dressed in, pumps and a dress and a wig and counsel and try to comfort people who have just lost their loved ones. And the guy said, look, this is a ministry for me in a lot of ways. I can't have this type of shock to my people. A guy that, who is the lady that Flip Wilson used to make fun of as Geraldine? Kind of looked like Geraldine, with a 5 o'clock shadow and a voice like Barry White trying to comfort these people, hey baby, and with the wig and everything. I mean, it just was something that he didn't want to have to accomplish. Now the good news is we actually won that case at the trial level. The federal government, the Obama administration, has appealed that to the Sixth Circuit Court of Appeals in Cincinnati. So we'll see how that goes. But that's a developing area of the law, and that's where these whole dressing and grooming things are coming in now, this cross-dressing situation. As a matter of fact, Eric, who's going to talk to you in a minute, will talk to you a little bit about the whole bathrooms in school thing. That's another big issue, guys' access to girls' bathrooms. I think that's about it on those. Let me see how I'm doing on time. I'm doing okay. Just wanted to bring up two things before I open it up for questions. And that is expressive businesses. Businesses that have are print shops or that do calligraphy or that somehow use their artistic talents to provide a service for somebody. That can include florists or bakeries or photographers. They actually have a little bit more protection when it comes to who they do business with and who they don't. Now, that law is in a state of flux. As a matter of fact, we've got a case right now called Hands-On Originals involving a T-shirt maker in Kentucky. Blaine Adamson is there, the guy in the blue shirt that you see. He has a sincerely held conviction to not do print work for people if it would further something that would violate his convictions. Like he doesn't do Halloween wicked stuff. He doesn't do witches or goblins. He doesn't do things that would depict somebody being killed or murdered. And as a matter of fact, he had a request recently to do a gay pride festival, and he didn't want to do that. Doesn't have any problem doing any other kind of work for people homosexual folks, but he decided that he wasn't going to further that agenda. They sued him. He actually won at the trial court level. That case is on the Court of Appeals in Kentucky right now, too. As a matter of fact, he had several, print shop, T-shirt print shop from New Jersey, owned by some lesbians who actually weighed in on his behalf at the court and said, look, there are T-shirts we don't want to print either. We shouldn't have to use our talents and our abilities to further a cause we don't agree with. And that is essentially the American way, and we should certainly fight for that. But if you're in an expressive business like that, be aware of that. If you have a situation come up where somebody's asked you to do something that violates your convictions and you feel uncomfortable doing it, give us a call. We'd be glad to talk to you about it. We may be able to walk you through it and help you out. Another area of concern are medical professionals. Probably don't have any of those here today, but I'm sure you know some. But the medical professionals there's pressure being put upon them right now to participate in things like abortion and end-of-life stuff. We just filed a case in Vermont on behalf of some doctors who are being forced to counsel people about physician-assisted suicide if they're 6 months terminal. So what that would look like is if you're a doctor and you have a biblical worldview and say, no, suicide is not biblical, what we can do is you're 6 months, probably got about 6 months to live. We can really help you manage your pain with palliative care. There are some treatments, special treatments that we can give you that might they're trials, they might help. And you should also consider killing yourself. Now, most of us would think, I don't want to present that option to them. But in Vermont, if you either have to present that option to them or you have to refer them to somebody who will. You have to facilitate that process. That's problematic. We also represent the Stormans, a company up in Ralph's Thriftway. They have a pharmacy up in Washington, actually have several of them. Do not want to carry the morning after pill because they say that's an abortion-causing drug. They're sincerely held religious beliefs say that they can't do that. Well, the state of Washington passed a law specifically to require them to do that. That case is ongoing. And then, of course, the other thing that you're probably aware of is the whole sex change thing. There are some doctors who don't want to participate in that, and understandably so. I'm going to skip the religious business thing and just go over this last slide, and I'm going to open it up for questions real quickly. So what can you do to protect your business? And I think the most important thing is you can adopt a statement of faith and purpose. And you can go online. If you download our Employer's Guide to Faith in the Workplace at adflegal.org, you can download it. We've got some examples of how to do that, and it really is helpful. I think one of the things you can do also is you can review all your job descriptions, and if there are any job descriptions that you think you have to have somebody who believes a certain way, for instance, if you own a Christian bookstore and you have somebody who provides information about Bibles, they have to have some knowledge of Bibles or believe, then that's possible that you might be able to only hire a Christian for that particular job. And then the last thing is you should have a policy that talks about your religious convictions and what kind of work you do and don't do, including whether you participate in same-sex marriage or participate in abortion in any way. And that's, and you should include gender identity in that. All right, so last thing, and then I'll take a few questions. I mentioned earlier that religious organizations are a little different. We also have a resource for them. It's called Protect Your Ministry. You can get that at adflegal.org. Just type in Protect Your Ministry in the little search window up at the top right-hand corner. You can download that for free, and you can also download this Employer's Guide to Faith in the Workplace. I think that's pretty much it for content. Let's take a few questions, and then I'm going to turn it over to Eric, who's going to talk about public employees. Yes, sir.
This last year, or the last couple of years, the state of California or the city of Los Angeles, on their symbol, had to remove the mission symbol off of the state emblem. That was a religious symbol, but it was also a history symbol. So how did they justify it?
So the question is, in the state of California, one of the cities there has, I believe the name of the city is like, it has a mission in there like a lot of California cities do. That's very part of the history, one of the reasons why it was there. And in the city seal, they have a picture of that mission, and it has a little cross on it. Somebody complained, and I think, as I recall the case, they decided to take it out, or it might have gone to court, and the court required them to take it out. That is a very sticky, I don't want to say a developing area of law. It's a very fact-specific area of the law. There are some cases where they've upheld it. Las Cruces, New Mexico, had as their part of their city seal. I think they had the City of the Crosses there in New Mexico. They had they as I recall, that one actually got upheld because it was historical. Of course, the California courts are a little less likely to uphold something like that in California. But generally speaking, if it's a governmental piece of stationery or a seal on a cop car or whatever, if it's got religious symbolism on it, the courts have been very hesitant to uphold that, which is silly because if you go to the Supreme Court of the United States, it's got a picture of Moses with the Ten Commandments up there. So there's a big double standard. The good news is we've won a couple of those cases recently. As a matter of fact, our case that we represented, the town of Greece, they opened up their town meetings every month with a prayer. And that case went all the way to the Supreme Court, and we won. The court said they are allowed to open up town meetings with prayer. That was a big thing. So it's an ongoing battle. We're winning some, losing some. Yes, sir. Hold on just a second. I think, okay. So let's go with this man. You'll be next after the guy with the mic.
I'm in an organization that has one employee, but probably 75 to 80 volunteers. Does the Title VII cover those volunteers?
It does not. It does not. They have to be employees. Now, whether somebody's an employee or a volunteer might be a different thing. What state do you live in?
California.
Uh-huh. All right, so California, in California, you have to, if you have 5 employees or more, then you can't discriminate based upon religion. If you have just 1 employee, no harassment. So you have to be, the only thing that you're really covered by is the anti-harassment thing with regard to your
So I
employee.
can't harass myself.
Yeah, well, yes. You probably could. I bet you could figure out a way to do it. Sometimes I feel like I harass myself. You walk into a room, why did I come in here? I don't know. I'm arguing. You know where I really get harassed by? Is Siri. Do you argue with your phone? What are you talking about? Can't you understand English? So I don't know. Maybe that's harassing Siri. Yes, sir. This man right here.
I don't know if you've ever been to Harrisburg, Pennsylvania,
I have.
the capital.
Uh-huh.
If you go inside the building and you look all around the top, it says, "In God we trust."
Right.
And is that present a problem or how did they get around it?
Well, they, first of all, that's all on all our money too. And the courts have held pretty repeatedly that that does not, as a national motto, that doesn't violate the Establishment Clause. What's the difference between that and a cross on a mission, on a seal? I don't know. And the Supreme Court would say, I don't know either. They don't have a good test to tell you what the difference is. They just say, we know it when we see it. So it's the Establishment Clause jurisprudence is in a mess. So there is no real difference between that and anything else. However, things that have been there a long time and are things like "In God We Trust." As a matter of fact, and Ohio's national state motto is "With God all things are possible." Courts upheld that one too. So, yes, sir.
On federal or state level, for public institutions like schools, what's the stand now on things like Bible classes or extracurricular activities? And is there a difference between K through 12 where the people are obligated to go and the university where you're not obligated to go?
Eric is going to talk a lot about that here in a second, but let me just say, generally speaking, you can still have Bible clubs, and generally speaking, at the university level, there's a lot less restriction, and because the courts see them as older, they're not as susceptible to influence, and so there's a lot less restriction. All right, one more, and then I'll transfer over to Eric.
Obscene language.
Okay, 2 more. Go ahead.
Obscene language. Had a company for 26 years. We basically said no obscene language in the company area.
Right.
And did that for 26 years. Sold the company to a large company, national company, and their sales meetings are mixed with men and women. When we have a sales meeting now, it's like 22 people in the conference room, and just foul language from men and women, back and forth.
Mm-hmm.
So I asked the ownership if they could, quiet that down somewhat, because I was in the meeting, it was offensive to me and other people I knew.
Right.
And they said no. So I don't go to the sales meetings, and they
Yeah.
asked me to go to the sales meetings because of my experience, but I say no, I don't go to any of the sales meetings.
Right.
I
Yeah.
don't know. I need clarity on that.
Yeah, there's absolutely, yes, employer can say no foul language. There's no First Amendment right to freedom of speech in a private workplace. So, for instance, like Colin Kaepernick, who says he's expressing himself by kneeling down to national anthem. Jerry Jones at the Dallas Cowboys, getting a plug in for the Cowboys again, he said, my guys aren't going to do that. I own the stadium. I pay these guys bills. They don't have any First Amendment rights here, and that's true. There's no First Amendment rights in a private workplace. So if there is no First Amendment right to cuss, if he was in a federal courthouse, then yeah, that he has free speech rights. But yeah, they could shut that off, and you have every right not to be exposed to that. Absolutely, absolutely. Yeah, there's no First Amendment right in that context. If he was out on the street or if he's in a public park, well, yeah, that's First Amendment protected, but not. Yeah. Yeah. So the question is whether it's harassment or not, and it can rise to the level of harassment. but it's got to be pervasive, it's got to be unwelcome, and it's got to affect your job duties. So it could be, foul language could be harassing, be tough, difficult to prove. All right, last one, I'm sorry.
This is just in regard to the In God We Trust.
Yes.
God being a very, there are atheists, of course, but that it's a very universal concept of God, whereas the cross is distinctly Christian. And I think that is a distinction that the court is looking at.
It might be, but we also use crosses to commemorate the dead. And we use crosses for other reasons that don't really have much religious significance at all. If you go to over in Normandy, you see whole fields lined up with crosses, and certainly there's some religious significance to that. But the bottom line is that's not what it's for. So crosses aren't just about being about Christianity. Crosses also have some historical significance, like in the Las Cruces case that I mentioned. So thank you very much for your time, and Eric Hall's going to be, thank you. All right, take care.
Thanks so much to Kevin and all of you. Some of the questions that you were just asking just now are anticipating what I'm going to talk about, because like what Kevin was just saying, his talk was primarily focused on the private workplace, and my talk is going to be primarily focused on the public workplace. And so there we're going to talk a lot about the First Amendment and what the First Amendment, Establishment Clause, Free Exercise Clause, and Speech Clause say to these sorts of issues. I have an outline, which I'm going to ask some friendly folks, maybe Emily, maybe John, to pass out as we get going. So let me pick up my outline, which I have here, and then I have a PowerPoint presentation as well, but I have a lot more information in this outline. So thank you, John, if you can pass those out to people. And I'll just be working my way through this, and then, again, kind of using the PowerPoint just for direction. And then I'll take some questions at the end. Let me get my water. Okay, so again, my name is Eric Hall. I work at a private law firm, Lewis, Rocha, Rothgerber, Christie. Our firm is pretty large. We have 280 attorneys throughout the Southwest, Colorado, California, New Mexico, Nevada, Arizona. One of our practice groups is the Religious Institutions Group, and so we represent a lot of churches, a lot of ministries, Christian ministries, Jewish, Muslim, Hindu, Buddhist. We represent all the denominations, all the religions of the world, with primarily First Amendment questions and just helping them live out their calling, live out their vocation as they're doing their work in the world. So that's where I get my experience in what I'm going to be talking about today. Again, today my focus is on the government side. And again, like Kevin just said very correctly, and we all need to remember, the First Amendment applies to the government. It applies to every area of government, both the federal government, all the branches, also the state governments and local governments. The First Amendment does not apply in the private sector, right? So the First Amendment does not apply to private employers directly, okay? So those sorts of distinctions are going to be very important in my talk. So again, hopefully you have a copy of my outline. We're going to start, and where we're going to start is with the text of the First Amendment itself. So this is what the First Amendment says. It says, Congress shall make no law respecting an establishment of religion. That's the Establishment Clause. Now notice there, it says, Congress shall make no law respecting an establishment of religion. It does not say Congress shall make no law respecting religion. Congress can and does make laws about religion. For instance, they wrote Title VII. Into Title VII, they wrote a religious exemption, which allows private employers to discriminate on the basis of religion, like Kevin was just saying. He mentioned that in passing. That law is constitutional because, yes, that law is about religion. It respects religion. It carves out an exemption for religion. We're also going to talk about the Religious Freedom Restoration Act, which is another law Congress passed. It's about religion. It carves out some space for religious exercise in our country, given our long religious heritage in our country. It's about religion, but it doesn't establish a religion. That's the big distinction. We're going to talk about that a little bit more, the difference between establishing a religion or endorsing religion by the government and and just being part of a religious nation. Okay, so the Establishment Clause. Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. That's the Free Exercise Clause. We're going to talk about that. Or abridging the freedom of speech. Third area that we're going to talk about. Or of the Press Clause, the right of the people peaceably to assemble and to petition the government for redress of grievances. Those other clauses we're not going to talk about today because they don't have as much litigation around them. So we're going to focus on just the first three. So on page 1 of my outline, again, we're going to focus on the Establishment Clause, Free Exercise Clause, Free Speech Clause, and then my part B here is general principles. I've picked out 3 of what I think are the most important general principles. If you want to understand First Amendment law, which is complex, but if you want to understand it, I recommend start with these first 3 principles, and it'll help you go a long way to understanding what the courts are doing when they're handling these tough cases, okay? The first one is, who is acting or speaking? Let's see if I got it. Government speech versus private speech. That is critical. You have to focus in very carefully on saying, okay, in this context, who is acting or speaking? Is it the government speaking? Is it the government acting? Or is it a private person? All right, and I've got this quote here, which I think illustrates. This is a quote taken directly out of this case, Santa Fe Independent School District versus Doe from 2000. There is a crucial difference, the U.S. Supreme Court wrote, between government speech endorsing religion, which the Establishment Clause forbids, and private speech endorsing religion, which the free speech and free exercise clauses protect. So I do a lot of work with public schools and religion in public schools, so that's a great example here. So a teacher is the government. Teacher at a public school is the government. So if he or she is endorsing religion, whatever religion that might be, Christianity, Islam, Judaism, they're endorsing it in the sense that they're trying to get their students to become a Christian or to become a Jew or to become a Muslim. Okay, that violates the Establishment Clause. That's crucially different from a student who, say, wants to have a Bible study, organize a Bible study during lunch, wants to pray before a test, wants to pray before their meals, right? That student is not the government. That student has a free speech right and a free exercise right to do those things in the public school. So if a teacher comes to that student in the lunchroom and says, oh, I'm sorry, you can't organize a Bible study here, we're a public school. No, the student should say, I have a free exercise right and a free speech right to organize this Bible study during lunch, otherwise a free time, with whoever wants to join me, and you can't stop me as the government, okay? So crucial distinction, government speech or private speech. The second important thing to think about as you're trying to understand these cases in the Establishment Clause context is what are the purposes of the separation of church and state? Now, we all know the separation of church and state is not in the Constitution, but courts use that analogy to figure out how to decide these cases. Well, what are these purposes? I'll suggest there are 3, and again, they're in my outline. The first one that courts often turn to is they say, the separation of church and state in our country has prevented religious wars and societal strife. And I think that's true as a historical matter, right? We look around the world today, we look around the world for decades, for centuries before us, and our founding fathers knew this. They said, when the government starts promoting, establishing a religion, it causes religious wars and societal strife. And so we in our country have decided we want to separate government and religion, and by doing that, prevent some of those problems. So that's one of the purposes that courts see in the Establishment Clause. The second one is protect religious liberty. And what do the courts mean by religious liberty? If you turn on to page 2, they primarily mean 2 things. They mean, first, the freedom of believers of any religious denomination to gather together and worship as they see fit. And the government can't stop that. So the freedom of people to come together and form churches. That's the one that we usually forget about, but it certainly is a part of our constitutional religious heritage. People are able to come together and say, we want to form a church, we want to have a house church in my basement, and we want to worship God in whatever way that is for us. The government can't prevent that. The second thing is freedom of individual conscience. So I might have, again, a religious belief about all sorts of things, and the government can't force me to believe something that I don't want to believe. And this goes all the way back again to our founding fathers, both of these principles. And James Madison is said to have famously seen the Baptist preachers in Virginia who were being locked up because Virginia was primarily an Anglican state at that time. They were locking up the Baptist preachers, and James Madison was horrified by this, saying a Baptist preacher should be able to preach his Baptist gospel if he wants to, and not have the government of Virginia lock them up because the government doesn't like what's being said by this particular preacher. And so and again, Madison was the author of the First Amendment. Okay, so that's a second important purpose of separation of church and state. And the third one is protecting religious minorities. And the strain in our country has been, we might have a religious majority. For instance, Utah is almost exclusively 90-some% LDS church, but there are religious minorities in Utah. Right, there are various parts of our country, right? Texas, the Santa Fe Independent School District case, which I mentioned earlier, that's primarily West Texas, Baptist country. But the people who brought that case were Catholics and Jews who felt like the school district, the government, was favoring the Baptist religion over their religions, okay? And the First Amendment was designed, a third purpose was to protect religious minorities in that context. All right, so that's the second big principle of how to understand the Establishment Clause. The third one is context matters. And I know this drives people crazy because then you get down to these factual distinctions. It makes it very hard to understand some of these cases. But I'm telling you, context matters. You got to look into the history of what has happened. And the best example of that I can give you are these two 2005 Ten Commandments cases, which are on page 2 of my outline. There's Van Orden versus Perry, where you had the Ten Commandments. They were sitting in front of the State House in Texas, and somebody sued in roughly 2002, 2003. It got up to the U.S. Supreme Court in 2005. The Supreme Court said, we're going to look at all the history of how that Ten Commandments monument got in front of the Texas State House. We find no violation of the Establishment Clause. Texas was not trying to establish Judeo-Christian thought by having those Ten Commandments in front of the State House. Why? Well, because actually when you look at the history there, that Ten Commandments was given by, I think it was the Fraternal Order of the Eagles, a private organization. There are a whole lot of other historical monuments in front of the Texas State House right there. There was some even question about whether the Ten Commandments was given to promote the movie with Charlton Heston way back then, so maybe it was a movie promotion and not. But the point was you add up all these factual details, and the court said there's no compelling evidence that Texas is trying to advance Judeo-Christian beliefs by having the Ten Commandments in front of the State House. As opposed to the other 2005 case, McCreary County versus the ACLU, where they struck down a Ten Commandments monument being put into the central courthouse in Kentucky. Why? Because they looked at the history there, and the history there was the Chief Justice of Kentucky had just gotten elected, and he was a Christian man, and he wanted the Ten Commandments in the courthouse, and so right after he was elected, he had some group move it in, right, and he had the keys because he was now the Chief Justice, and he put it right in the center of the atrium, so everybody walking in would see them, and then the ACLU sued him, saying, you're using your power as government agent, as Chief Justice, to advance your religious beliefs, and religious minorities are feeling like they're outsiders. And again, the ACLU won. He lost that case because the U.S. Supreme Court said, look, you look at all those facts, and yeah, it does look like this person is using his power as a government person to advance his beliefs on behalf of the government of Kentucky. So those Ten Commandments had to go. Right? So I think that was a great example. I think the U.S. Supreme Court took those two tandem cases to show, among other things, that context matters. Okay, that's why in Colorado, we have a Ten Commandments in front of our State House as well. And there was a lawsuit about it many, many years ago. Same rationale as the Texas case. So context matters and how these things play out. Okay, let's keep going. We've been talking about the Establishment Clause. I'll mention the Lemon Test very briefly. It's kind of spelled out here on page 2. The Lemon Test says a law or government action establishes religion and therefore violates the Establishment Clause if it lacks a secular purpose, if its primary effect either advances or inhibits religion, or the government becomes entangled in religion. The second test, the endorsement test, is a kind of a takeoff on the Lemon Test. It just says if you take in all the facts and if you had a neutral, well-informed observer, would that observer say that the government is endorsing religion in this context? And then the third one, this is current First Amendment bedrock principle for the Establishment Clause. The government must remain neutral toward religion. It cannot advance religion, but it also cannot disfavor religion. All right? So let's give you an example, because these cases are only interesting. These principles are only interesting if you have examples. So let's say you have the mayor of Cathedral City. And the mayor of Cathedral City comes to a group called Christians in Commerce, and he comes here as mayor. And this private group called Christians in Commerce had just had a praise and worship session, right? Where they were praising Jesus Christ, and they were thanking that Jesus Christ was in their hearts. And then after that, the mayor comes up on stage, and he says a few words as mayor of Cathedral City, right? Is that an Establishment Clause violation? No, absolutely not. And I watched the mayor very carefully as to what he said. I could tell he was a good mayor, because he was here, he was welcoming us as mayor, but nothing about what he said as mayor, we in Cathedral City are a Christian city, or we adopt your principles of Jesus Christ. He was very welcoming to us. He said he was very pleased that there were groups like ours that wanted to see ethics and wanted to see kind of upstanding behavior in the workplace. He appreciated all that, right? And maybe his private views, maybe he's a Christian, I don't know. Maybe some of you all know. And maybe he goes to church on Sunday and there he praises Jesus just like we were doing that. That's all fine, because in that context, he's not acting like mayor. He's acting as a private citizen. But when he came on stage for us and was talking to us as the mayor of Cathedral City, he had to be very careful that he was not endorsing religion. But there is nothing wrong with a government official being at a private organization's event and watching or celebrating the fact that they were exercising their speech and for exercise rights as they were praying to God, and he was there, okay? So let's keep going with more examples. Free exercise clause. Okay, the free exercise clause, the most important thing to know about this clause in our constitutional jurisprudence today is a decision called Employment Division of Oregon versus Smith, which held this in 1990. This decision was written by Justice Antonin Scalia, the justice that just recently passed away. And if any of you know anything about the court and Justice Scalia, he was well known for being a very devout Catholic and for being conservative, politically conservative and constitutionally conservative. He wrote this decision, which holds this: neutral and generally applicable laws do not violate free exercise, even if they incidentally burden religion. What does that mean? Well, let me tell you about the Smith case. The Smith case was about two men who practiced Native American religion, and as part of their Native American religion, they smoked peyote. But peyote is a drug that in Oregon was classified as an illegal drug, and their employer said, you got to take drug tests, and if we find any illegal drugs in your system, you're fired. So they smoked peyote, they came to work, they were tested under the drug tests, they found this illegal substance in their blood, they were fired, then they applied for unemployment. And they said, we want unemployment from the state of Oregon, and they said, well, you got fired because you violated the drug test, and so we're not going to give you unemployment because that's one of the reasons that you can be denied unemployment. So they sued saying, well, we're exercising our religious beliefs, right? Smoking peyote is part of our spirituality. And Justice Scalia for the U.S. Supreme Court said, the unemployment compensation laws in Oregon are neutral and generally applicable, meaning they don't target religion and they apply to everyone equally. And so, yes, they might, the way this all played out might incidentally have burdened your religion because you were practicing your religious belief and then you lost your job and did get unemployment, but that does not violate the free exercise clause, right? That decision was a surprise at the time. It changed free exercise jurisprudence substantially at the time. It still holds till today, and it affects a lot of how you analyze these cases. And you'll see that example as we move forward. Let's keep going. Okay, now on to the speech clause. Okay, the free speech clause, again, applies just to the government. And couple principles. First, no viewpoint discrimination. So the government itself cannot engage in viewpoint discrimination. The government cannot pass a law which makes it easier for Republicans to speak on the airwaves, but makes it harder for Democrats to speak on the airwaves, or vice versa, right? The government cannot engage in viewpoint discrimination. All right, forum analysis. What does that mean? All right, got to understand this, and Kevin alluded to it. There are different fora, for all you Latin scholars, right? Forums, and you analyze how speech is protected depending on where you're speaking. So, if I go to the public park or a public sidewalk, right, and well, let's use the football example, right? If I'm a football player and I want to make a statement about Black Lives Matter or whatever, and I want to do that in a public park or a public sidewalk, I'm going to have a lot of speech protection, because the court has said the speech clause protects those areas as free speech zones, where you can get on your soapbox and you can kneel down and you can stand up and you can say whatever you want, and the government can't restrict your speech very much. They can pass what's called time, place, and manner restrictions, which says, all right, listen, you might be able to speak about your beliefs in whatever, between like 6 in the morning and 10:30 at night, but after 10:30, you got to put down the microphone and go home because people are trying to sleep, right? You can pass laws like that about, when people can talk, but generally in public, traditional public fora, you got to let people speak. All right, there are two other categories though. There's limited public fora, and there's non-public. And let me put them together and say, imagine a public school. Public school is government, right? Okay, public school does not have to open their building for speech unless they want to. They could say, any public school could say, you know what, we're going to educate our kids here, and after that, we're going to close the doors and nobody can use our building. Most public schools don't do that, but they could do that if they wanted. And if they did that, they'd say, okay, our building is a non-public forum, and we're just not allowing any speech there. And if I came and said, hey, I want to hold a meeting after school in your building, and I have a free speech right to do it, they'd say, no, you don't, because we never open up our building as a public forum. But what happens if a school did? And this is what most public schools do. They say, okay, we'll educate our kids from 8 to 3:30, and then after 3:30, we'll let community groups come in and use our classrooms for whatever they want. Okay, you've opened up a limited public forum. So let me give you a case to illustrate what happened. This is called the Good News Club case. This case came out of New York. And here you had a school district that said, after school, people can come in, and they had a policy on this. And you can use our classrooms, and anyone from the community who wants to build up the youth can use our classrooms. But they say in their policy, if you want to build up the youth in all sorts of different ways, talk about how to have a good character and how to rise up as a good young man or woman, that's fine, you can use our classrooms. But you can't use them if you're a religious group. That was the rule. And a group called the Good News Club, evangelical Christian group, said, we want to rent your rooms, and we want to have Bible studies, we want to pray, we want to teach the kids how to follow Jesus, and we see that the Boy Scouts are using your classrooms, and we see that the 4-H club is using your classrooms, and that seems to be fine, but now you're not letting us because of your policy saying no religious groups. And they say, yeah, because we're afraid that religious groups being in our classrooms will violate the Establishment Clause. It'll look like we're establishing religion. This case goes to the U.S. Supreme Court. The U.S. Supreme Court says, no, school district, you lose. Good News Club, you win. Why? Because first, it's not a violation for the government to allow, again, a private group, the Good News Club, to speak their religious beliefs, or to speak their religious beliefs in a government building. You've opened up a limited public forum, and these beliefs are their beliefs. No one's going to attribute them to you, so there's no Establishment Clause concern here. And as to the speech clause, you, the government, are not being neutral. You are allowing some groups, preferred groups in your eyes, to speak and to raise up the youth. And the example they use is you allow the Boy Scouts to come in and use space after class and talk about how Gerald Ford was an upstanding Boy Scout and you should emulate Gerald Ford and be honest and maybe you'll become president someday. In the same way, you, the government, must allow this religious group to come in and the Good News Club and say, you should follow Jesus and you should pray to God our Father. And that's the way you have the right sort of character. And the U.S. Supreme Court said, we agree with that. It violates the speech clause to deny religious groups the same access as non-religious groups. So that's the constitutional law of today. Okay, then the last thing I have here, again, speech cases are tricky, but it helps to think about the speaker, the speech, the government actor, and the government restriction. So again, let's just apply, and those four kind of factors come out of this book, footnote 2 on page 4, John Garvey's book, What Are Freedoms For? Very readable book, if you're interested. It's been out for maybe 10, 15 years now. But as a layperson, I recommend it to you. It has lots of great examples like this, helps you understand constitutional framework. Anyway, the speaker, the speech, the government actor, and the government restriction. Okay, let's take the Good News Club case. Okay, in the speech context, who is the speaker? The Good News Club was the speaker. What was the speech? They wanted to have private religious speech. What was the government actor? It was the school district. And what was their government restriction? They said, you can use our classrooms, but not religious groups. Right? And when you kind of use that framework, it becomes a little bit more understandable as to how you realize, oh yeah, that makes sense. The government is preferring secular speakers over religious speakers. That violates the speech clause. All right, let's keep going. And here, now we're going to apply some of these principles in the government context. So does anyone work for the government, like a government employee? Maybe one? Okay. Government contractor? All right. So you get this initial question of whether the First Amendment would apply to a government contractor. But put that aside. Let's go with just the straight up government context. There's special rules for how the First Amendment applies in the government employment context. And here's where the courts start. They say you got to distinguish the government in the context of government as sovereign, passing laws that affect all of us in society, and government as employer. And here, government as educator, running public schools. And when you distinguish between government as sovereign and government as employer, the court has said you got to allow the government to actually get its work done in the school context, actually educate kids. You can't allow some of these First Amendment principles to tie up the ability of the employer to get their work done. So let me give you an example. The Pickering case, Pickering versus Board of Education. And you can see I have this spelled out more on the bottom of page 4 onto page 5 of my outline. So the Pickering case, you had a gentleman named Marvin Pickering. He was a teacher at this public school district. There had just been a bond election where the school district had wanted to increase the taxes on all the folks there, and they had all these promises about how they were going to use the money. The voters voted that down. Pickering, a teacher, wrote a letter to the editor saying, I'm glad the voters voted that down because I'm a teacher and I'm up close and personal on how the school district spends the tax dollars they give you, and the last tax increase, they wasted that money. And let me tell you why I think they wasted that money. They gave more to athletics than to education, and I'll tell you this time around, the superintendent was really pressuring all us teachers to try and gin up support for this latest election. You can imagine the superintendent was not happy with that letter to the editor, right? So Pickering gets fired. He then sues under the First Amendment and says, wait a second, don't I have a free speech right to express my beliefs, right? And the court says, this is a hard case because here we have a gentleman who's both a citizen and a teacher. So how do they analyze it? Well, they analyze it, and you can see on page 5, the court I took out a quote that I think really encapsulates this case. The court says, the problem in any case like this is to arrive at a balance between the interests of the teacher as a citizen in commenting upon matters of public concern and the interest of the state as employer in promoting the efficiency of the public services it performs through its employees. So they come up with what's called the Pickering balancing test. And the first question is, did the employee speak as a citizen on a matter of public concern? In the Pickering case, the court said yes. Marvin Pickering was speaking not as a teacher in front of his classroom, he was writing a letter to the editor on a matter of public concern, a recent election about whether to raise taxes or not. So that question, the court said, undoubtedly yes, speaking as citizen on a matter of public concern. If the answer is no, as we'll talk about in these next two cases, then probably as an employee, you don't have any First Amendment rights. You're going to lose this case. But in the Pickering case, the answer was yes. So then if the answer is yes, you can see on page 5, number 3 towards the bottom, then the question becomes whether the relevant government entity had an adequate justification for taking the adverse employment action, in this case, firing him. And here the justification was, making sure the morale of the school district works well, not have dissension among our teachers. And the court said, that's a weak justification given the weighty considerations on the other side. The citizens being able to speak their mind about matters of public concern. And so then the last part of the test is the court balances these interests and holds for Pickering. Right? So he wins that case. Okay, let's fast forward. From there to the Connick case. Anyone ever heard of Harry Connick Jr., the singer? His father, Harry Connick Sr., was a district attorney in New Orleans. The Connick versus Myers case is about the father, the district attorney. So he's running the New Orleans DA's office, and he has an employee who doesn't like him. And the employee thinks that he's doing a bad job as DA, he's doing a bad job as a boss, and so she circulates a petition among all the other employees in the DA's office saying, tell me your views, a survey, tell me your views about whether you think Mr. Connick is doing a good job or not on all these different categories. He finds out about it, and he's mad, and he fires her. And she sues, saying, I have a First Amendment right, speech right, to speak my mind and express the fact that I think you're doing a bad job and circulate the survey. And he says, that is just eroding the morale and the culture, and I'm the boss, and there's certain ways you can bring a grievance to me, et cetera, but after I decide those things, then you got to fall in line, or else I can't run my DA's office, right? In the Connick case, the court starts with the Pickering test and says, it was her speech, was she talking as a citizen, as a matter of public concern? And they say, no, she wasn't. This wasn't a matter of public concern for the community at large. It was an employment matter inside the DA's office. She didn't like how he was running the office. So right there, she loses. She loses that case. Connick wins. Okay, same thing with the Garcetti versus Ceballos case. This is a more modern version. This is a 2006 decision, where in this case you had an attorney in the DA's office, I think this was in Los Angeles, who disagreed with the way the chief attorney, the district attorney, elected official, was prosecuting a certain case, and thought that the prosecution should have ended, so he expresses that. The DA overrules him and says, no, we're going to go forward with the prosecution. He doesn't like that. He complains about it inside the office. DA says, you're fired, and he sues, saying, don't I have free speech rights? Same analysis as under Connick, saying, no, you don't, because this wasn't a matter of public concern. This was how the office is being run in prosecuting this particular crime. You can see the reasoning. I give some quotes from Garcetti on page 6. The court said, the First Amendment protects a public employee's right to speak as a citizen addressing matters of public concern, pulling from Pickering. When a citizen enters government service, the citizen by necessity must accept certain limitations on his or her freedom. It makes sense, and it's just a constitutional fact. If you enter government service, you're going to have some of your First Amendment rights limited in that context. Not in other contexts, but in that context. The government as employer indeed has far broader powers than does the government as sovereign. Right? As government employer, I can put more restrictions on than I can, like passing a law saying we don't like speech about abortion in our public parks, right? That law is going to be, the second law is going to be unconstitutional. All right. And the court said there are two goals: to promote the individual and societal interests that are served when employees speak as citizens on matters of public concern, and two, to respect the needs of government employers attempting to perform their important public functions. Right? So in the Garcetti case, again, the DA won and the employee lost. All right. Yeah. Yeah. He wants a microphone.
Being recorded, so any type of questions, please. Thank you.
Just a quick question. I'm just wondering if on that government contractor, if Myers or the government area would ever countersuit if that person continued, or is there court cases or legislation that has shown that as well, reverse?
Countersuit, like a counterclaim?
Counterclaim in that regard, or is that, would that only be in the private sector?
Well, again, the employer would have to have an actual legal claim. What would be the basis of the employer's claim?
They don't have anything that they would
Yeah,
be
so
hurting for them. Okay.
Right, they wouldn't be injured in any way. As opposed to the employee, the employee was injured by losing her job. Right? And so she said, I shouldn't have lost my job, that's how I was injured, so I want the courts to redress my grievance by saying, reinstore me or pay my back pay because they violated my First Amendment rights. That's not the case for the employer, where the employer wasn't injured. The employer was the one saying, no, you're fired because you were creating dissension with your survey. So I can't imagine there would be a counterclaim in that circumstance.
Thank you.
You're welcome. All right, I'm going to carve out some time for questions at the very end, but let me just touch on a couple more cases. See how much time we have. Okay, it's 11:24, and I have until 11:45. Is that right? All right, so we'll do a couple more and then we'll stop. So let me talk about the Johnson versus Poway Unified School District. This is a California case. You look on page 7 of my outline, and you see there is a gentleman named Bradley Johnson. He was a well-respected math teacher at his school. He had taught math at this school, public school district, for years and years and years and years. He had 2 big banners in his classroom. They were 7 feet long, they were 2 feet wide, they were red, white, and blue, and they said these things. You can see on page 7. The first one said, "In God we trust, one nation under God, God bless America, God shed his grace on thee," in all caps, just like it was written there, red, white, and blue letters. And the second banner said, "All men are created equal, they are endowed by their Creator." Now, he was a math teacher, so he didn't refer to these banners, they were just up on his wall. And nobody complained about them until, and this is the way these cases always come up, somebody, another math teacher, got into a dispute with him about the math curriculum, didn't like how it was going, so they were and so this other teacher says, "I bet you I can get him in trouble because of those banners on his wall." So he goes to the principal and says, don't those banners violate the Establishment Clause, right? Isn't that Mr. Johnson promoting religion as a teacher? Is that a problem with that? So the principal finally takes notice, goes down to his room and says, "Could you take the banners down, or could you make them smaller, or could you put some other things to make a little context? I'm feeling a little uncomfortable about this." And he says, "No, you school district have a policy," which is true, the school district had a policy. Number 5 on page 7, where the district said a teacher can hang things on their walls, personal messages on their walls, as long as they don't materially disrupt the schoolwork and as long as they don't cause substantial disorder or interference in the classroom. And he says, that's what I got here. And I've been teaching for years and no one's ever complained about this until, what's his name, who doesn't like me, is now complaining about it, and now you've taken an interest in this. I don't want to take them down, I shouldn't have to. Your policy allows me to have these. So and then he also says, and besides, there are other teachers in the school who've got other religious things on their walls, do not making them take their things down. For instance, one teacher down the hall had Tibetan prayer flags with writings in Sanskrit and images of Buddha. Well, one teacher had a poster of John Lennon with the lyrics of the song Imagine, right? Flip to page 8, right? You know the song, "Imagine there's no heaven, it's easy if you try, no hell below us, above us only sky. Imagine all the people living for today. Imagine there's no countries, it isn't hard to do. Nothing to kill or die for, and no religion too." He says, you let the John Lennon poster, that's clearly an atheist like promotion. You're letting that poster stay up. There's another person with a Mahatma Gandhi poster, another person with Gandhi's 7 social sins, a teacher that had the Dalai Lama, another teacher that had Malcolm X, had these bumper stickers. He says, you allow all that stuff on the classroom walls. Why are you making me take down my posters? She says, oh, because I feel like you're really establishing religion with these things. He's like, these are all sayings, right? He was smart. These are all sayings from like our coins and our national heritage, right? The Declaration of Independence, right? How can you, but she insists the school board eventually gets involved. The school board takes a vote. They say, you got to take down the things, the posters. And he says, I will take them down under protest, and he sues. And they go to court, and I think this case is an interesting case because the district court and the appellate court came out differently. The district court looked at this case, and they applied a forum analysis. That judge in the district court said, I'm sure it should say he, there's a single judge, applied a forum analysis, and he said that you, public school, have created a limited public forum on the walls of your classrooms, where you've said to your teachers, you can express your personal views on the walls as long as they're not disruptive. And that looks like exactly what Mr. Johnson has done. So I find for him, right? And he's right, he wins. The case was appealed to the Ninth Circuit, and the Ninth Circuit reversed. And the Ninth Circuit said, no, actually the district court got it wrong in applying the forum analysis. What the district court should have done is applied the Pickering analysis because this is a government employee. And as a government employee, was he speaking as a citizen on a matter of public concern? No. He was speaking as a teacher because the only way he was able to put up these posters at all was his job as a teacher. And these statements about, our American religious heritage were not a matter of public concern. It wasn't something being discussed in the community, like the vote on taxes in the Pickering case. So he wasn't speaking on a matter of public concern, and he wasn't speaking as a citizen. So the teacher loses. And then the court goes on to say, and about those other teachers and the other things up, this isn't a matter of the school district discriminating against Judeo-Christian beliefs and in favor of these other beliefs, because all those other things were not religious statements. And then the court goes on to try and explain why they were not religious statements. For instance, the teacher that had the Tibetan prayer flags up, she testified and she said, oh yeah, those prayer flags, I wasn't endorsing Buddhist practices. I was just using that to describe what actually goes on in that part of the world and the people that believe those things when they go up Mount Everest and things like that. So all the different teachers came in and tried to explain those things. For me, when I read that case, I get a little disturbed about that part of the court's analysis, right? But that is the way the court wrote it up. That's the way the testimony came in. Oh, and by the way, I think these cases are fascinating. That's one reason I love being a lawyer. You can just Google these cases. They'll come up. You can find them. You can pull them up. You can read them yourself. I think they're very interesting. Let's see if a couple more details. Oh, so on page 9, the Ninth Circuit said, because of the position of trust and authority that teachers hold and the impressionable young minds with which they interact, teachers necessarily act as teachers for purposes of a Pickering inquiry when at school or a school function in the general presence of students in a capacity one might reasonably view as official. It was kind of the way they were summing that up. They did, interestingly, have a couple exceptions, which, especially for the Ninth Circuit, which is known as a liberal circuit, I thought was very interesting. They did say, so let's say you're a public school teacher and you've got bumper stickers on your car and you're running an errand as a teacher or as an employee. Is that okay? Like, sure, that's okay. I mean, come on. And then the second one is, let's say there's an emergency and like everybody's panicked, like an earthquake, and the teachers are panicking, the students are panicking, and everyone's in an earthquake, and people pray, and the teacher starts leading the class in prayer. Would that be okay? They say probably yes. Even though it would be a teacher praying with the students, given the circumstances, that'd probably be okay. I thought that was very interesting. All right, let's see. Talk about let me just make the point, which hopefully you all have understood from my talk so far. It is perfectly fine for a public school to teach about religion. You can teach about the world religions. You can teach about Christianity. You can have a public school class about the Bible, where they're reading the Bible as, again, the most important book in Western civilization by far. Most influential book by far. You can't understand Shakespeare. You can't understand much of literature if you don't know the biblical stories. Just as a historical matter, as a literary matter, totally fine. What you can't do as a public school or a public school teacher is you can't say, you should read the Bible, O students of mine, and you should believe it, and you should adopt Jesus as your Savior, or any other religion, right? I mean, there's a good case out of the 10th Circuit where there was a music teacher. He was Mormon, and he worked at a public school in Utah, and he had his class, his music class, sing songs they were, Baroque songs, Bach, Mozart, some of these others from years ago, and they had religious lyrics. And when they would travel, they would go sing in some churches and temples. And a student said, you, music teacher, are promoting your LDS faith on all us students, and I'm a religious minority, and I object. The teacher won. Why? Because the teacher said, no. I'm not picking these songs and going to these places because I'm trying to convince you to become a Mormon. I'm picking these songs because they're some of the most beautiful songs written, and I'm picking them for their musical quality, not their religious quality, and we're going to these venues to sing, not because I'm trying to convert you to become a Mormon, but because they're free and they've got great acoustics, and so it makes good sense to sing in a place with good acoustics that are free as we travel around and do our music program, right? So there are secular reasons for my decisions. And that's why that teacher won that case. So again, this goes back to the perennial questions about can you sing Christmas carols at the public school concert? The answer is it depends on why you're picking them. If you're picking the Christmas carols as the music teacher because you want the kids to believe in Jesus, you're probably violating the Establishment Clause. If you're picking the Christmas carols because they're part of our heritage and they're beautiful songs and you're choosing them for their musical qualities, then you're not. The way most people, as you all know this, the way most music teachers deal with this is they now say, okay, we'll pick some good, beautiful, worthy songs, Christian, some Jewish, some other religions. We'll sing all of those, like diversity of songs, and you're probably protected. Okay? All right. Let's see how much time we have. Okay, so I'm running out of time. I do want to leave time for questions because you guys were asking great questions earlier. So I will skip over a couple of these cases. I'll just mention Congress passed in 1993 the Religious Freedom Restoration Act, right? Bill Clinton was president at the time. So notice the date, 93. In 1990, the Smith case came out, totally changed free exercise constitutional law. And so Congress and President Clinton responded by passing the Religious Freedom Restoration, that's why the word restoration is in this, the name of this law, Restoration Act, which gives additional protection for free exercise of religion in our country as a statutory matter, right? Now, this act was struck unconstitutional by the U.S. Supreme Court as applied to the states and local government, but it still applies to the federal government. So there's more free exercise protection under this statute because of Congress's act in 93. There are also a lot of what's called state RFRAs, State Religious Freedom Restoration Acts, where you can see on my outline, if we skip forward to pages 12 to 13, 21 different states have passed their own versions of state RFRAs. 10 more states have RFRA-like provisions. So there are a lot of states that at the state level provide more protection for free exercise of religion than current U.S. constitutional law. And then state constitutions, right? Colorado has 3 provisions in its state constitution dealing with religious liberty. So again, if you're ever involved in this sort of area, make sure you're telling your lawyer, look up the state constitution as well. Some state courts, not actually many, most state courts just interpret the state constitution similar to the First Amendment, but some of them actually interpret them differently. A couple more things before we get to a hot button case. Title VII also applies to federal, state, and local government. Okay, so I'll close by talking about the Masterpiece Cake Shop case, which is on page 14 of my outline. This is a pretty new case. Let me couple my discussion here with a couple pages later. I talk about the Elaine photography case. The cases are analyzed very similarly, and they're very recent. You maybe have heard about them. So the Masterpiece Cake Shop cake, this is from Colorado. A guy named Jack Phillips, again, I'm on page 14 of my outline. He owned and had a cake shop called Masterpiece Cake Shop. He was a Christian man, is a Christian man, and he believed that God had given him artistic abilities, and he wanted to express those through making cakes and other baked goods, and making them beautiful and delicious and selling them. So he had his cake shop, and it was popular in Denver. And then two homosexual men, Charlie Craig and David Mullen, wanted to order a same-sex wedding cake from him. And he declined. And he said, I'm sorry, my religious values teach me that marriage is reserved to one man and one woman, and so I can't make you a wedding cake. I can sell you other things. I can sell you a birthday cake. I can sell you other baked goods. But I'm not going to use my God-given talents to make something that I disagree with as a religious matter. All right? So they sue him, and the case first goes to an administrative law judge called an ALJ, and the cake shop loses. Jack Phillips loses. And then he appeals that to the Colorado Court of Appeals, and he loses there too. I don't know why it didn't go to the Colorado Supreme Court, but it didn't. This case, as I'll tell you, has been appealed to the U.S. Supreme Court, and is currently pending there. I don't know if the court is going to take it. You all know that the U.S. Supreme Court only takes the cases it wants to. It's currently pending there. On my outline, page 816 says, the petition to the U.S. Supreme Court was filed on July 22nd, 2016, and the Colorado Commission on Colorado Civil Rights Commission will respond on November 29th, and then the cake shop will have probably into January to file their reply. So sometime in 2017, we'll decide, once we have a new justice, the court will decide whether they're going to take this case or not. Let me just describe the reasoning of the parties. So first, Jack Phillips said, oh, I'm sorry, I missed one big important fact. Colorado passed in 2008, it amended its Colorado Anti-Discrimination Act, which is the state equivalent to Title VII. The Colorado Anti-Discrimination Act, CADA, C-A-D-A, like Title VII, says if you are a public employer or if you're a public accommodation, that's the key here, you cannot discriminate on the basis of race, religion, national origin, disability. In 2008, they added sexual orientation, right? So the two homosexual plaintiffs sued under the sexual orientation provision, saying you're a public accommodation, meaning you are a cake shop that sells your goods to the public, and as such, you cannot discriminate on the basis of sexual orientation, because Colorado law says so. Right? Like Kevin says, Title VII has not added sexual orientation yet, because it's never gotten through Congress, although it's been proposed every year for the last, I don't know how many years, 15 years. This is under Colorado law, okay? And so that's how these plaintiffs sued. They said, you're violating the public accommodation statute, discriminating on the basis of sexual orientation. And Mr. Phillips said, I'm not discriminating on the basis of sexual orientation, because I will sell you anything else. I'm not selling to you because you're homosexual. I'm not selling to you because my religious beliefs don't allow me to celebrate a marriage that's not between a man and a woman. And the Colorado Court of Appeals said, nope, you can't make that distinction, because there are too many places where status and conduct go together, and homosexuality is one of those, where you can't distinguish, and there are a bunch of different cases which do say this, you can't distinguish between the homosexual conduct and the status of being homosexual. And so here they say, a same-sex marriage is what homosexual people do, homosexual men do, and so the fact that you saying you'll make them other things but not a wedding cake, you're discriminating on the basis of sexual orientation. The analogy they used two. They said, again, in a restaurant, you couldn't have a restaurant that said, all right, all you men, you can come into my restaurant and you can buy anything off the menu, but you women, if you come into my restaurant, you can only buy the appetizers. I'm not going to sell you anything else. The Court of Appeal said that's similar to what you're doing here with these homosexual men. The other example they gave is a famous quote, a tax on a yarmulke is a tax on Jews, because they say only Jews buy yarmulkes. So you can't have a tax on a yarmulke and say, oh, we're not trying to tax the Jews, because since only Jews wear yarmulkes, tax on a yarmulke is a tax on Jews. So they use that quote here to say, no, refusing to make a same-sex cake is discriminating on the basis of sexual orientation. That's the first thing they said in response to Mr. Phillips' first argument. His second argument was a speech clause argument. So the first argument was, I'm not discriminating. The second argument was, the government cannot force me to say something I don't want to say. The government can't force me to promote same-sex marriage when I disagree with it. And the court there rejected that argument, saying, you know what, making a cake is not expressive speech. Yeah, that's the part of this decision that I disagree with, especially when, as you can, I think art is speech too. But here the court said, one thing the court said was, this is not your speech, Mr. Phillips. It's their speech because they're the ones ordering the cake. So any reasonable observer would say that they're the ones that are engaging in the speech, and you're just kind of the messenger for it. I disagree with that, but that's what the court said. And the second thing they said is, oh, you could put a disclaimer in like your window or on your website saying, the things that I do don't respect my beliefs. But the biggest problem I had with the court's decision was a different quote. I quoted on page 15 for you. The court said, a wedding cake in some circumstances may convey a particularized message celebrating same-sex marriage, and in such cases, the First Amendment speech protections may be implicated. However, we need not reach this issue because Phillips denied Craig's and Mullen's request without any discussion regarding the wedding cake's design or any possible written inscriptions. So that just makes me shake my head as a lawyer, because the court there is saying, well, if they had gone on and like talked about how to design the cake, what the cake should look like, then maybe it would be speech. But since they didn't do that, we hold this is not speech. I just find that wholly unconvincing. But that is the court's reasoning. You can read it for yourself. Don't shoot the messenger. And then the last thing is he said, don't have free exercise rights in being able to deny to make this cake. And the court, again, looked to Smith and said, we interpret our Colorado State Constitution provisions in the same way as the First Amendment in the Smith case. The Colorado Anti-Discrimination Act is a neutral law that's generally applicable. And so the fact that this might incidentally burden your free exercise rights means you lose, right? So that's how that case has been decided. And the last thing I'll say, because I know I'm out of time, is actually the most disturbing part of this case for me is the ALJ ordered as part of its remedy, not just that he had to make and sell wedding cakes for same-sex couples, but that, as you can see on page 16, he ordered that Mr. Phillips and his employees had to go to comprehensive staff training. Which to me, when you think about that, that's the government requiring him to go to training to change his mind, to change his beliefs, right? Hold on. We got lots of microphone, all sorts of problems, time's up. But to me, as a lawyer that deals in this area, that's the government telling him how to think. The government telling him you must give up your religious beliefs. And in our country, that is the scariest part of this decision. So if nothing else, if I were a U.S. Supreme Court justice, I would hope they would take that case just to clear that misconception up and say the government can't do that. They might be able to force him to sell cakes on the theory that, listen, if you're gonna sell cakes to the public, you got to sell cakes in accordance with all these protected classes, but don't, as the government, tell him how to think. So I'm out of time. Thank you so much.